crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. For the next half hour, we've got a topic we're going to deal with and break down for you that we believe you're going to be interested in, and we would love to have you be a part of that conversation. Details on that coming up in just a bit, but first, just some ground rules of how you could be a part of our conversation. All throughout the program, you'll see numbers and information scrolling on the bottom of your screen, ways you can call, text, email, and get in touch with us, get your questions to us. 844-LAW-TALK is a number you need to commit to memory because that's the number to know. But also, Hollis Wright makes available attorneys who are standing by live all throughout the program tonight. So for the next half hour, if you'd like to get some free, off-air, confidential legal advice, that opportunity is there for your taking. Again, that's thanks to the folks at Hollis Wright who make those attorneys available. Leading our conversation from the firm of Hollis Wright, Carter Clay, good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well. You holding up well? Everything all right in the Clay household?
Yeah, everything's going well. I'm ready to talk about product liability this evening.
All right, so that's one of those phrases that you hear. I think to the layperson, you hear product liability, but what are we going to talk about? What does this cover, and what's this topic about?
So product liability kind of is what it sounds like. It involves consumer products. And it is situations or circumstances where a manufacturer or wholesaler or distributor or retailer, somebody within the chain of distribution, can potentially be held responsible or liable in circumstances where a product being used by somebody hurts them or kills a loved one or family member. So that's essentially what we're talking about when we talk about the body of product liability law.
Yeah, and so I guess we're commonly referred to, and you see them on the news, defective products, I guess. But so how would you define, what is a defect, and how is that defined legally?
So a defect legally would be a dangerous condition in a product that is unreasonably dangerous given what it is supposed to be used for. And there's a body of law in Alabama called the Alabama Extended Manufacturer's Liability Doctrine, commonly referred to as the AEMLD, and that is statutory law in Alabama that has been created over many, many years of judicial opinions that have come about to create a law that could potentially hold somebody in the chain of distribution responsible if their product is defective and hurt somebody. But there are three main kinds of defects that are recognized under the law.
Okay.
You've got a design defect, potentially, a manufacturing defect, and a failure to warn. Okay? And typically, all of our cases involve one or more of those three potential types of defects that we're looking for in circumstances where somebody gets injured or killed while using a product.
So especially design and manufacturing defects, help us understand those.
I can differentiate those. So a design defect is a situation where the design of the product, so you can take any product out there, a chainsaw, a utility terrain vehicle, an automobile, they're going to be design specifications for those particular products, okay? And what you're claiming there is the design, the specifications that go into the manufacturing, those designs are defective in some way. How do you go about proving that? Well, you have engineers look at the design drawings, and oftentimes those engineers will say, okay, well, here's the defect in the design because there's a safer alternative. There's a better way, a feasible way to design this product in such a way that eliminates the danger that is being caused by the design itself. Okay? A manufacturing defect, on the other hand, is a situation where we're not criticizing the design. The design specifications are fine, but the production of the material, the manufacturing of the product itself was not done consistent with that design. For instance, the design called for 7 screws and they only put 6 screws in the product from a manufacturing standpoint, and the lack of that one screw caused the product to fail in some way. A classic example that I think I've given on the show before is I handled a case involving an industrial saw with an 18-inch steel diameter saw blade that sheared off the saw, ricocheted around in the machine, came out and hit my client in the leg. He almost lost his leg in the incident. Well, the design called for the countersink holes where the bolts go through to affix it to the machine itself. The design specifications called for one size, but it was manufactured inconsistent with the design specifications. What they call the countersink holes were oversized. They were larger than what the design called for, and that caused excessive vibration on the heads of the screws, and eventually they failed. The saw blade comes off, my client gets injured. So in that case, we pursued a manufacturing defect claim, inconsistent with the design.
Yeah. All right, so you hear a lot about this group, the CPSC, the Consumer Product Safety Commission. So who are they, what are they, and what is their role when it comes to product liability?
So in previous shows, we've talked about the Food and Drug Administration, and that's the governing body that controls food, prescription drugs, medical devices, medical equipment, and there is a clearance and approval process through the FDA. The CPSC, or the Consumer Product Safety Commission, is similar to the FDA. They don't really have a clearance or approval process. You don't have to run consumer products through that agency necessarily to bring your product to market. However, the CPSC, like the FDA, has oversight and monitoring responsibilities over consumer products. So they will get information, they will do investigations, they will do follow up with companies. If there are a lot of complaints that are coming in on particular products, they will increase the level of resources that are committed to investigating those accidents and trying to make determinations as to whether that product may be defective, and they have influence over whether or not a defective product might need to be recalled or withdrawn from the market.
So they set the standard that companies have to meet in terms of safety and those sort of...
I wouldn't say they set the standard, but if they're alerted to problems with the products itself, they will intervene, and they will then look at the standards through the industry and see if they're meeting those standards, and if they're not, they may do further investigation and ultimately require a recall or withdrawal from the market, or corrective measures to be taken.
Right. Now, a lot of times whenever we refer to the FDA with those are the ones who deal with medications and drugs and all that, right? A lot of times what I've heard is that they're just overwhelmed. There's so many new products coming out all the time. How can they keep up? Is the same true with the CPSC?
The same is absolutely true. I mean, the CPSC has oversight responsibilities for 15,000, 20,000 consumer products. There are all kinds of new products coming into market. They are not a body that is there to just oversee and rubber stamp design specifications and manufacturing instructions. They don't have the resources and manpower to do that.
All right. Well, let's step aside. We're off to a good start. Appreciate you being with us as we head to break. A reminder, Hollis Wright also does a great job on social media. If you'll search the term Hollis Wright, you can find them on YouTube, Instagram, Twitter, Facebook, all over the place. A great resource for you. So check them out there if you are someone who is on social media. Stay tuned. We've got more of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
We love helping people. I think everyone at this firm feels the exact same way, that the reason we do what we do is to help people. And this show gives us the biggest platform possible to help as many people as we can in the community.
Welcome back into the attorneys. Before we return to our questioning of Carter Clay about car accident cases, reminder, attorneys from Hollis, Wright standing by live. You want to speak with them or text them. The numbers to know 844-LAW-TALK or 205-324-3600. All right.
We could characterize this as the David Lamb cross-examination, questioning Carter Clay. I am in the hot seat over
I
here,
am,
right?
man. It's all you, man. It is all you.
I don't have another guest to help me out.
Nobody else to fall back on, but you are handling it extremely well, sir. All right, so a question we've got here, kind of an interesting scenario. So I think I might be hurt, but I'm not sure. Should I call for medical assistance? You touched on this a little, but this is pretty common, I think. Folks don't know. You don't want to be trouble. You don't want to waste anybody's time. But also, we're not doctors.
Well, it is a very common issue that we see. And what I would tell people is I would err on the side of getting medical assistance. A lot of times what we see is the individuals think they might be hurt, but they're not hurt badly enough, and they don't want to ride an ambulance or go to the emergency room, because if you get in an ambulance, you're going to the emergency room. If people think that they're hurt, they need to get some form of medical assistance. If it's not bad enough to get in an ambulance and go to a hospital, go to your primary care physician either later that afternoon or the first thing the next morning, just to document that you were involved in an automobile accident and get a record of the physical complaints that you have. Because the longer it goes on where you don't get any form of medical treatment, or you at least don't record that you were in an accident and record the physical complaints that you're experiencing, the less serious the insurance company is going to take your claim, because their impulse reaction is well, obviously, if you were really hurt, you would have gone to the doctor, right? And there are a lot of people out there that just sort of try and tough through it, don't want to go to the doctor, and they allow it to linger on, and they wind up going 2 or 3 weeks or even a month before they go to the doctor, and that really can be detrimental to the claim.
Yeah. And question we've got here, do I have to report the accident to my insurance company?
Yes, almost all insurance companies are at least going to require you to inform them that you were in an accident. Now, there's a critical distinction between that and making a claim on your insurance, okay? The reporting of the accident to the insurance company is really just a formality that you have to comply with, so that the insurance company, if they want to take certain steps in terms of gathering information or talking to certain people, whether it be other people involved in the accident or the other person's insurance company, they want to have the right to be able to do that under certain circumstances. That does not mean, however, that you are making a specific claim to get money from your insurance company. And why is that important? Because a lot of people are out there, well, if I make a claim, my insurance premiums are going to go up, and I don't want my insurance premiums to go up. So that's a critical distinction. You need to report it to your insurance company, but you can tell your insurance company, look, I'm not making a claim right now. I may be, though, in the future, and I'm reserving my right to do that, but I'm just providing you with the fact that I was in an accident, and if you all need to do or take certain steps, you're obviously free to do so.
Okay, what about talking with the other driver's insurance company?
I would be very cautious and guard against doing that. A lot of times the other insurance company will contact the person that was hurt or was not at fault, because they want to find out, hey, what happened to you? Have you gone to see a doctor? What are your injuries? But sometimes, and this is really where a person has to be careful about talking to the other person's insurance company, is they want to get a recorded statement from you.
Okay.
And a lot of times when the insurance company is contacting the person that was hurt or the person that was not at fault, you may think as the victim that this is a clear liability case. Oh, this was clearly not my fault. It was the other person's fault. But you don't know what the other person told his insurance company. The other person may have told the insurance company that it was not their fault. So the insurance company is contacting you to find out what happened in the accident, and they may be setting you up to dispute liability. So now all of a sudden you've given a recorded statement, you've said something unknowingly that has hurt your claim. Next thing you know, the insurance company's telling you, oh, we're not paying you anything because our insured says the accident was not their fault. So I tell people all the time, don't give recorded statements to the other insurance company. Now, before we move on, this is critical. Your insurance company may also ask you to give a statement, and if they do, you are required under your insurance policy with your insurance company to give a statement. So you really can't avoid doing that.
Right. But that is also, is that the kind of conversation you would have with your attorney before speaking to your insurance?
Yeah, well,
folks
I think this kind of
advising?
ultimately gets to the heart of the matter is which I always tell people, don't try and handle your personal injury claims on your own, because there are a lot of pitfalls in that process. And so the quicker you can get to an attorney, the quicker you can hire an attorney, they can evaluate all of these types of issues on your behalf, and they can intervene. What we do is we send letters of representation immediately to the insurance companies that basically say, hands off. We're representing these individuals. All of your communication needs to flow through us. If you have a request of us, you let us know, but do not communicate with our client. Takes the burden off them. They don't have to make these types of decisions, and we can help them through the process.
Another question, what if I wasn't wearing my seatbelt? Does that mean that I don't have a case?
No, you certainly still have a case. Obviously, the seatbelt had nothing to do with causing the accident. The accident would have happened regardless. Now, the injuries may have been enhanced because you were not wearing your seatbelt, but as a general rule, they cannot use that against you in terms of reducing the compensation that you are provided. But there are some exceptions to that. It gets a little bit complicated, but the general rule is no, it cannot be used against you.
Do you still see folks who are not wearing their seatbelt?
Sometimes, but not as often anymore. And you know, we passed a law a while back where everybody in the vehicle has to wear a seatbelt, not just people in the front seat.
Right. All right. Buckle up.
Yep.
For sure. All right, we're stepping aside. Our final break of the evening. As we do so, a reminder, we've got a little bit of time remaining, so if you want to join the conversation, call, text, email that info at the bottom of your screen. Stay tuned. We're coming back right after this quick break.
I'm attorney Tyler Vale with the law firm of Hollis, Wright. Many people ask the same question: why should I hire a lawyer? While there may be some legal situations that do not require you to hire a lawyer, the clear majority of legal problems would certainly benefit from having competent counsel involved. To begin with, the law is complicated. Even experienced lawyers typically do not represent themselves in court. A solid case with clear liability can quickly unravel without the help of a trained attorney. Lawyers understand the rules of evidence and know how to properly lay a foundation to get critical evidence and testimony admitted into court. Lawyers are trained to recognize legal problems early on in a case and can help avoid pitfalls that unrepresented individuals may fall into. Lawyers can also increase the value of a case by getting experts involved to help prove additional damages that an unrepresented person may not realize they are entitled to. An experienced lawyer has probably worked on cases like yours and can give insight to negotiating a fair settlement based on recent jury verdicts and settlements that unrepresented individuals may not have access to. Another important reason to hire an attorney is because the person or business you sue will likely have legal representation themselves. Non-attorneys are generally at a disadvantage when squaring off against opposing counsel or doing business with another party that has legal counsel. The law is complicated, and an attorney who is representing your adversary may try to take advantage of it. Our law firm offers free case consultations that allow you to meet with us for free during a face-to-face meeting, where we can discuss the type of case you have, the potential value of your case, and your likelihood of success. This initial meeting can help you decide whether you need to hire a lawyer. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. About 8 minutes remaining in the show. So if you want to take advantage of that opportunity to speak with the attorneys from Hollis Wright who are standing by live, about 8 minutes left for you to do so. The numbers to call or text 844-LAW-TALK or in the Birmingham area, 205-324-3600. Back to some questions we've got here talking about car accident cases with Carter Clay. What if the other driver's insurance company wants a copy of my medical records? Should I release them?
Well, if you get to that point, then you've already violated and made a mistake, violated one of the rules I talked about earlier and made a mistake, which is you're trying to probably handle the case yourself, which you need to get to a lawyer early on, whether it's somebody at our firm or another firm that handles automobile accidents, because that's a tricky situation to be in. You're going to have to probably either provide them with copies of your medical records, which means you've got to get it, or provide them with some type of medical release. Oftentimes these insurance companies will ask the injured person to sign a medical release that will allow them to get all of your medical records from the beginning of time, which is an absolute no-no. You really don't want to go down that path. Again, get to a lawyer, let them assess each situation. Ultimately, the insurance company is entitled to get your medical records and your medical bills to evaluate the merits of your claim and make a determination as to the value of your claim. But you're best left with a lawyer making those types of decisions, especially as it relates to the timing of the disclosure, how you go about doing it, whether to sign a medical release so that the insurance company can get it, or whether you just provide the records to them. So that would be my suggestion.
Is that one of the most common mistakes you see, is that, because if I'm in an accident, or any of us unfortunate to be in an accident, I mean, I've been in two, I'm in my mid-50s and I've been in 2 accidents in my life, right? I would be so outmatched going against someone who all they do every day is talk to people who've been in accidents. I wouldn't know what to do. Is that a part of where the downfall is kind of in that?
That is, but ultimately what that leads to are settlements that are for significantly less than what the case is really worth. As you know, our cases are all handled on a contingency fee basis, which means we don't get paid unless we successfully recover for the injured person, and then we get a percentage of that recovery. A lot of people try and make the assessment of, well, even if I got a little bit less money, if I didn't have to pay a lawyer, I'm still coming out better. The problem is that typically the person is going to get a lot less money than would be offset by the attorney's fee. So they're going to come out to the negative under those types of circumstances. And also, people just in general don't have any idea how to value cases. Like how does a person that never handles these types of cases know whether their case is worth $5,000, $50,000, or $100,000 or more?
We'd Google it, I bet is what we'd do.
That's dangerous as well.
It is, yeah. That's not the best strategy, I promise you that. Another question we've got here. The other driver says the car wasn't his and belonged to someone else. How does that affect my potential claim?
So it's not going to affect the claim in terms of who the claim is against. Remember, the case or the claim, if you had to file a lawsuit, is against the driver that was driving negligently or carelessly that caused the accident. So in that respect, it doesn't change. What might change is which insurance company is going to provide that driver coverage to pay for the claim associated with the injuries that you sustained. So typically in that type of situation, it may be that the insurance company that was covering the automobile, that insurance company could kick in and provide the coverage, but it also may be that the driver has his own insurance, okay, and that insurance company might kick in as well to provide coverage for the at-fault driver. It really depends on the circumstances that led to that driver being in that particular vehicle. Was he borrowing the vehicle? Was it a temporary substitute for his own vehicle? So there are factors there at play, so it can influence which insurance company will pay the claim, but not who you pursue the claim against.
On this subject matter, it's kind of close to something that I hear you guys talk about a good bit, and that is uninsured motorist coverage, UIM, all that. Make sense of that for us. Whenever you all are talking about that, what are you talking about?
So from an insurance perspective, this is probably the biggest mistake that we do see people make.
Okay.
The uninsured motorist or underinsured motorist provision is a provision on your insurance, okay, that you pay a small or fairly nominal increase in your premiums to have this coverage. How does this play a part? Well, people that are driving on the roadways are supposed to have insurance, liability coverage on their automobile, but the minimum limits that you've got to have are $25,000. Okay? Well, what if you are at fault driving your automobile and you catastrophically injure somebody and you kill them? Well, clearly $25,000 is not going to be reasonable to compensate them for their injuries or to pay them if they lost a loved one.
Right.
So what do? Do you just accept the $25,000 and move on? Well, pretty much, unless you've got uninsured or underinsured motorist coverage on your policy. That is really supplemental coverage that can pay you through your insurance in the event that the at-fault driver either has no insurance or they have the minimum limits or they just don't have enough insurance to cover your injuries, okay? You can buy hundreds of thousands of dollars worth of uninsured or underinsured motorist coverage on your own automobile policies that will kick in the event that you find yourself in that situation. However, a lot of people reject the coverage. So under Alabama law, if you don't reject UM or UIM coverage, you've got it, okay? And you'll get the minimum limits of $25,000 for UIM coverage. So in that example that I gave you, you might have a total of $50,000 in coverage, but you can buy more UIM coverage through your insurance broker. But a lot of people reject the coverage because they don't want to pay the additional premium, and that is a huge mistake.
And it's not very expensive either.
It's not very expensive.
Yeah, one of the more reasonable.
Yeah.
All right, just about a minute remaining, so we're almost out of time, but I want to give you the opportunity, just a final thought from you for our viewers tonight.
Well, one of the things we haven't talked about really in this show is the distracted driving. And we handle automobile accident cases all the time involving distracted driving where people are using cell phones. And it is a huge problem, and people are getting catastrophically injured and killed because of the use of cell phone and just through other distracted driving issues that we see people having to confront while they're driving in their automobile. And I would just caution people, obviously we make a living off of representing injured people, but people just need to be really careful out there and pay attention to what they're doing and put the cell phones down.
Yeah. Good stuff, Carter. I think we covered a lot of ground. Yeah. Enjoy the time with you. As always, thanks for coming in. Always grateful for Carter and the team there at Hollis Wright coming and sharing their expertise with us. We really do appreciate it and hope it's been beneficial to you. Thanks so much for joining us, and we'll look for you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.